Hi there, I'm James Dapperchi, and this is Coffee and a Case Note. Team, today we're going to have a chat about a plaintiff, and the plaintiff is both the sole beneficiary and the executor of an estate. And what they do is they are sweating on the transfer of some shares, or more specifically, the registration of that transfer. And so what they do in January is they cause their solicitors to send 2 letters off to the relevant company to try to cause the registration of the share transmission. They want to become owners of the shares. Understandable stuff. And they receive no response to either letter. Then later, as we move into the next month of February, the solicitors for the directors of the company say, look, we're expecting instructions soon, but importantly, those solicitors act only for the company's directors and not for the company itself. And so what our plaintiff decides to do is decides to commence proceedings, to go to court to cause the registration of this share transfer. Now, proceedings are commenced. You file your documents, you kick the court proceedings off, you serve your documents on the other side, and after going through all those initial steps, what happens is the registration actually occurs. And so on the day set down for the hearing of the matter, that hearing isn't actually required because what the plaintiff is after has already happened. The share transfer has been registered. And so everything's tied up in a neat little bow except for legal costs. Now, what the plaintiff says is, look, defendant, you completely capitulated to my claim. You did everything I wanted. And also, because I'd written to you a couple of times and you'd done nothing, you hadn't answered, the commencement of these proceedings was necessary for me to get that outcome. It was completely reasonable for me to commence proceedings because you wouldn't have done anything if I hadn't commenced them. And so you should bear responsibility for paying my legal costs. Now, what the court did is exercise its discretion. And as many of you will know, the court has a really broad discretion when it comes to costs. And so the court had to think through, right, what is the appropriate outcome of this costs dispute? And what the court found was that each party should pay their own costs. Now, the court had to think about what the plaintiff had to say and said, well, yes, it was not unreasonable for you to commence proceedings when you did. You didn't necessarily do it too quickly. But importantly, in the court's calculus, there was very little time between the sending of that second letter in January, and it was only the second letter in January where they clarified whether they were seeking the registration in their capacity as executor or as sole beneficiary of the estate. So it was only a couple of weeks before proceedings were commenced. It was only a couple of weeks between the sending of that precise letter and the commencement of proceedings, and that arguably could have been a little bit longer. You could have allowed the other side a bit more time. And so in a finely balanced decision where the court has a broad discretion, what the court decided to do was to say, look, each party should be paying their own legal costs. And I hope that funny, fiddly little chat about legal costs and registration of share transfers and all that sort of fun stuff was of value to you. And I look forward to catching up again soon for another coffee and another case note. Cheers.